Please subscribe and don't forget to press the bell icon to get notified whenever we upload a new video.
This is the latest that we are getting now from the NCLT, that the Tata Sons have scored a victory in the NCLT. The NCLT has basically dismissed the petition that was filed by the Mistry camp. This is the news that we are just getting at this point in time, that the Tata Sons, the decision of the NCLT has gone in favor of Tata Sons board of directors competent to dismiss the executive chairman. This is what the NCLT has to say, that the board of directors is competent to dismiss the executive chairman. This was one of the arguments that was made by the Mistry camp against the Tatas, saying that the board had acted as a dummy board and that it was in fact the trustees of the Tata Trust that were controlling the board, and this was in fact oppression and a violation of the Companies Act. Also going on to say that Cyrus Mistry allegedly leaked information to the media. This is what we are getting from inside the courtroom. The NCLT has dismissed Cyrus Mistry's petition. This is a big relief for the Tata Group, big relief for N. Chandrasekharan and Ratan Tata. So essentially, at this point in time, what we are getting to understand is that the NCLT says Mr. Mistry's conduct did not augur well for the smooth functioning of Tata Sons. I think we do have reactions ready as well. Do we have HP Ranina with us? Mr. Ranina, big win for the Tata Sons. Of course, this is going to be appealed by the Mistry camp, but on the face of it, big victory today for the Tatas. The NCLT basically saying that the board of directors was competent to dismiss the executive chairman, that Mr. Mistry's conduct did not augur well for the smooth functioning of Tata Sons.
Well, certainly it is not only a big victory for Tata Sons, but it's a great setback for Cyrus Mistry camp, because it is they have passed virtually strictures against Cyrus Mistry, saying that he acted against the interest of the company. So I think it's a terrible blow for Cyrus Mistry to say, because if the NCLT has come to the conclusion that he acted against the interests of Tata Sons, then certainly, Cyrus Mistry has its great, the stigma on Cyrus Mistry that he acted in a manner which was unbecoming of a chairman. And this is very, very unfortunate for him. Yeah.
I just want to add, Mr. Ranina, for the benefit of our viewers who might be just tuning in, the NCLT has also rejected the proportional representation for Mistry Group on board of Tata Sons, so that plea has been rejected as well. Also going on to say that there is no merit in the allegations regarding C. Sivasankaran, Air Asia and Nano, where basically Cyrus Mistry had alleged that there were instances of quid pro quo, that the board had been made to toe the line because these were investments that Ratan Tata wanted to make, and hence Cyrus Mistry had questioned those decisions, including the decision of the Tata Group taking the Nano project forward. The NCLT also going on to say that there is no merit in the allegation against Ratan Tata, Mr. Soonawala, that they were acting as super directors, cannot restrain Tata Sons from converting to a private company. Let's go across now to more reactions. Gopal Jain, senior lawyer in the Supreme Court, also with us on the phone line. Gopal, a big victory there for Tata Sons. The NCLT dismissing the petition filed by Cyrus Mistry and basically suggesting that Mr. Mistry has acted in a manner that was not in the best interest of the group.
Yes, I think it's a big victory, and NCLT is now a high-powered body, decision-making body. And I think it will put a quietus to this controversy. And more importantly, when you have such a conclusive determination, it's important because it will stabilize things and things can now move on. And this becomes a matter of the past. So it's an emphatic, clear, conclusive decision in favor of the Tatas. And even the aspersions.
But do you really believe, Gopal? Do you really believe, Gopal, that this is going to be a matter in the past? Because this, I'm sure, will be appealed by the Mistry camp.
No, Shireen, there are two things. Obviously, legal processes can continue. But what I'm saying is there is a determination and adjudication. So two parties can have contesting positions. And the first port of call, the NCLT under the Companies Act, has taken a conclusive and given a determination and also said that what Mr. Mistry did was not in the interest of the company. So I'm saying to that extent, it's a settled issue with obviously legal processes going on. But this is a good vindication and an affirmation, as I call it, an independent adjudication by an expert body versus what two contesting sides of parties are saying. I think to that extent, it's a matter of the past in terms of having a finding by a high-powered expert body.
Gopal and Mr. Ranina, I'd request you to just hold on. We also got Mr. V.R. Mehta of the Sir Darabji Tata Trust joining us. Mr. Mehta, this is big relief for the Tata Group, in fact, for the Tata Trust as well, because one of the key contentions of Cyrus Mistry was that the Tata Trust and its trustees were acting as a super board, that you were undermining board management of Tata Sons. Mr. Mehta, your reaction on the fact that the NCLT has dismissed the petition filed by Cyrus Mistry?
Yes, it's a big relief for the trust as well as the Tata Sons, and I'm glad that the NCLT has accepted the submissions made by Tata Sons in the case against the petition of Mr. Mistry and his companies. So it is a matter of great satisfaction, but let's see what happens hereafter, because I'm sure the legal battle is crossed only one level or one stage, and I suppose we'll see the other side taking it to the next level of appeal.
Right. Mr. Mehta, you know, given the fact that this is likely to be appealed by the Mistry camp, but given what we've heard from the NCLT, questioning the conduct of Cyrus Mistry, saying that proportional board representation, that plea has been dismissed, the fact that allegations made against Ratan Tata and Mr. Soonawala acting as super directors, that plea has been dismissed. Do you believe that today the Tata camp, led by Mr. Ratan Tata, find themselves to be vindicated?
Absolutely. There's no question of any other conclusion, because you see, we have all along been saying that there is no merit in those allegations, and there's no substance at all in the allegations he was making against the trust directors or the Tata Sons as such. So in that sense, absolutely, it is a very great vindication of the position. And what the case has done is that it is accepted that this effort all through has been the alignment of Tata Trust and Tata Sons interests, and that has been validated by this judgment. So I suppose it's a matter of great satisfaction, and I hope at this stage I don't want to say more about this, but definitely the position has been totally vindicated. And what I can say, one thing is that under the garb of minority oppression, an effort was being made to really have a majority oppression, oppression, and it would have been a travesty if that kind of thing were to be accepted. I mean, here is a minority group of shareholders trying to question the powers of the majority director to make sure that the conduct of the company in which investments have been made is in alignment with the objectives of the trust, and for receiving the income for their philanthropic activities. So it's a big boost, and anything else would have hurt the efforts, large-scale efforts of the Tata Trust in carrying through their philanthropic activities.
Okay. Okay, Mr. Mehta, I'd request you to just hold on. Let me bring in Jane Gupta, former ED at SEBI, also with us, corporate governance expert. This couldn't have gone any better for the Tata Group, Mr. Gupta. Virtually on every account, the NCLT has said that the Cyrus Mistry camp had absolutely no basis for making the claims that they made, whether it was oppression or it was mismanagement or it was running a board that was virtually being controlled by the Tata Trust. The petition being dismissed, life can now move on as far as the Tata Group is concerned, of course pending appeal, but big setback for the Mistry camp and a big victory for the Tatas?
I would say it is neither a setback for Mistry nor a victory for Tata because it was expected. Tata never would have thought that they will have a adverse judgment from the tribunal. And Mistry, although they tried their best, in the heart of their heart, they knew that...
Why would you say that, Mr. Gupta? Why would you say that the Tatas would not expect an adverse reaction, an adverse verdict?
I will tell you. Because once you believe in the justice system, then how can you say that a person who is claiming oppression was himself in charge of that ship for the last 3-4 years? Now, unless it was a physical operation that somebody held him hostage, otherwise there could not have been, because he was taking all the decisions, he was party to all the decisions, he was signing all the documents and doing everything. So how can this be called an operation? Because what letter Mr. Mistry had written about the instances of operation, instances of mismanagement, all he was the party. So you can't, after 3 years of enjoying something and say, turn around and say, oh, hey, I was not there, I was being oppressed. So then secondly, as Mr. Mehta rightly says, that under the garb of minority protection or minority oppression, you can't really oppress the majority, because ultimately somewhere the democracy has to work. You minority have to be granted only as much right as are available to majority. You can't give it a right which is going to alter the entire landscape of corporate structure.
Yeah. So let me go back across to VR Mehta. So, Mr. Mehta, in a sense, the demand that the Articles of Association, specifically Article 75 of the Articles of Association, be changed, be dropped, those demands that the Mistry camp was making now are unlikely to be taken forward. So the Articles of Association will stand as currently they are, at least for now.
Yes, actually, you know, this Article 75 in almost the same form has existed since almost 70, 80 years. There's nothing new which has come in this. And to now allege that this is something which is oppressive, I think it doesn't make any sense. It doesn't make any sense to anybody.
Okay, Shailesh Haribhakti and Suhas Tuljapurkar also with us. Shailesh, NCLT ruling in favor of the Tata Group, saying that there was no mismanagement, there was no oppression of the minority, and that the claims being made by the Cyrus Mistry camp are unfounded. Your first reaction?
Well, I think it is not wholly unexpected, but I need to read the judgment fully to look at what caveats, what is the nature of the judgment, to see whether there are further appeals possible or not. And I don't think we should consider this is the final end of the matter.
No, I don't think anyone is suggesting that this is the end of the matter. But for today, on all counts, it looks like it is a win for the Tatas of the NCLT, whether it is...
absolutely resounding on all counts.
It is resounding, yeah.
So it is a resounding victory, but I would still like to read the order completely before
You're
I
absolutely right, but Suhas, I understand that, and I understand your reservations, but Suhas, let me bring in your reaction. And once again, for the benefit of our viewers who might just be tuning in, the petition filed by Cyrus Mistry has been dismissed by the NCLT. The NCLT saying that the board of directors was competent to dismiss the executive chairman, that Mr. Mistry allegedly leaked information to the media, that his conduct did not augur well for the smooth functioning of Tata Sons. The NCLT has rejected the proportional representation of the Mistry group on the board of Tata Sons, going on to say that there is no... Abhishek Manu Singhvi, counsel for the Tatas, also with us. Mr. Singhvi, appreciate you joining us here on CNBC TV18. I was just, for the benefit of our viewers, reading out some of the key parts of the judgment from the NCLT today, saying that there is no merit in the allegations made by the Mistry camp with respect to Mr. C. Sivasankaran or Air Asia, etc., or the Nano project. Your first reaction, Mr. Singhvi, on what this verdict now means?
Well, Shirin, I have lived with this case in the first round in NCLT we won, the second round in NCLA, which we won partly, but then on the third round today, which we have won. So obviously, the smell of victory, the taste of victory is sweet and nice. And I feel, because I spent a lot of time in this case, I think it is a judgment, higher appellate authority towards, obviously is not there, because obviously the losing party is expected to go up. We are happy that this long thing at level judgment has been delivered. Obviously, no one is infallible. People can have it.
Mr. Singhvi, can I just request you to hold on for just a second? We're getting Mr. Kadam and Mr. Parasaran outside the NCLT as well, your colleagues who've been battling with you. Just a second, sir.
With a detailed judgment, not summarily, dismissed, rejected, particularly the allegations against Mr. Tata and Soonawala have been considered in great detail and rejected as totally without substance and baseless.
Sir, also one argument as far board representation is concerned when it comes to the proportionate shareholding, that has also been rejected. Yes, so Tata Sons will not give any board representation as well?
Absolutely. What they will do, I don't know, but I can say that the court has held that they are not entitled to claim proportionate representation because the articles of the company and the provisions of the Companies Act, there is no place for this in this company.
Kadam, a couple of important observations in the or the conclusions. One, they say the board of directors is competent to dismiss the executive chairman.
Yes.
They've said that.
They said so, yes.
Very clearly. So
yes,
therefore, the Mistry argument was, this was taken as any other item in the... Therefore...
That was one argument. The other argument was that the selection procedure followed. The same procedure should be followed for dismissal. They've said that's not required.
Second one, they've said Mr. Mistry allegedly leaked info to the media, to the income tax authorities, therefore hindering the smooth working of the board.
Yes.
Very important.
That is a finding of the NCLT, that also is a justification by itself separately for removal of Mr. Mistry as a director from the board.
Yeah, no merit in the allegations against Mr. Shivashankaran, Air Asia, Nano. These were important allegations.
All those allegations relating to Mr. Shivashankar, Asia, etc., have all been rejected as being without any substance and merit.
Do you think
used were merit in these allegations?
So one very did not mention anything when it comes to transfer of equity held by the two firms of Cyrus Mistry to be understood at all.
Well, that is Ravi Kadam, one of the counsels for the Tata Sons. We spoke with Abhishek Manu Singhvi, who has also been representing the Tatas, and we now have Mohan Parasaran, former additional Solicitor General Counsel for the Tatas, also with us. Mr. Parasaran, appreciate you joining us here. So on all counts, the NCLT dismissing the petition of Cyrus Mistry. What does this now mean, Mr. Parasaran? And if you can share with us any more details from the judgment.
See, we are yet to go through the main detailed judgment. The court itself only read most of it.
Yes, Mr. Parasaran, go ahead. Well, we lost that line with Mohan Parasaran, the former Additional Solicitor General and Counsel for the Tatas. We'll get back to us, but to quote Abhishek Manu Singhvi, the taste of victory is sweet, and that is the mood in the Tata camp at this point in time. Mr. Mehta, you were listening in to what both the Tata counsels had to say, Abhishek Manu Singhvi as well as Ravi Kadam. Do you believe that there are investigative agencies that are looking into the allegations being made with respect to the investments that the Tatas have made with Mr. C. Sivasankaran, as well as the possibility of bribery and corruption in Air Asia? That's a matter that is currently under investigation. So that continues to be an irritant. I'll come back to you, Mr. Mehta, in just a second. Mr. Parasaran, sorry, we lost your line, sir. You were taking us through what you believe are the operative parts of the judgment, which has gone resoundingly in favor of the Tatas.
Absolutely. See, all the allegations pertaining to oppressive conduct, mismanagement, etc., referenced by Mr. including the removal of Mr. Mistry as the executive chairman. And
so they have said that there was absolutely nothing wrong with his removal. But on the issue of does this now end the controversy with respect to the articles of association which were in question, sir? Okay. Well, torrential downpour in Mumbai, so struggling with the phone lines a bit. Maybe we'll get Abhishek Manu Singhvi back with us to get more details on this. Request my producers. Yeah, but do dial Abhishek Manu Singhvi once again so that we can get more clarity on some of the operative portions of the judgment. Mr. Mehta, as I pointed out, that investigative agencies are still looking at some of these issues. So very quickly, sir, that continues to be an irritant, does it not?
Line is bad.
Mr. Mehta, can you hear me, sir? Mr. Mehta, can you hear me?
I can hear you, but the line is noisy.
Sure. I was just asking you that, you know, the fact that investigations are still underway on matters like C. Sivasankaran and AirAsia, that will continue to be an irritant for the Tatas, will it not?
If I hear you right, you're asking about the allegations in the case of loan to Mr. Sivasankaran and also the AirAsia case. Now, I'm not aware of the kind of allegations that are there and what investigating agencies are looking at. But it is noteworthy to say that the very same things were considered by the NCLT and they have found no merit. These were the same charges made by Mr. Mistry in the petition, and the NCLT has found no merit in that. So I would like to say more than that at this stage because I am not aware what the investigative agencies are looking at, and certainly they are not looking at anything concerning the trust. So I think
Mr. Paras,
that's all I can say at this stage.
Fair point. Fair point. Mr. Parasuran, we've had you on a scratchy line, sir. You know, whether it is allegations to do with the board being controlled by the Tata Trusts, claims that Ratan Tata and Mr. Soonawala were acting as super directors, or the fact that, you know, investments by the Tatas to do with C. Sivasankaran as well as the AirAsia matter have also been dismissed. The claims of mismanagement with respect to the Nano project have also been dismissed. Is there anything else that we've missed out from the order that will sort of set the course for the way forward?
Yeah, it's a wholesale dismissal, but the issue as to whether the conversion of the company into a private company, that will be examined separately by the NCLT under Section 14 of the Companies Act 2013.
Okay. Okay. So that decision has yet to be taken, whether... So that's going to be that's going to be decided later.
That was not indicated by the court today.
Okay, okay. All right, so that's one pending issue that we'd require for more clarity on. But anything else, Mr. Parasaran, and what do you now expect in terms of the next course? As Mr. Abhishek Manu Singhvi pointed out, that this is the third victory in a sense, but yeah.
All the other articles have been upheld, including Article 75, which actually provides and empowers the company to compulsory purchase the shares of shareholders. That article has also been upheld, you know.
Okay. Right. So, Article 75 has also been upheld by the NCLT.
Yes.
So what do you expect now in terms of the next course of action, Mr. Parasaran?
See, possibly, I think, I can't say. This can land up before the NCLT. The petitioners can go before the NCLT, and we have to wait and see, no? But it is a step forward for the Tatas.
Right.
Thank you.
It is a step forward.
Yeah.
let me bring in the other side as well. Somashekar Sundaresan joins us. Som, appreciate you joining us here on CNBC TV18. You know, the Tata Council saying that the taste of victory is sweet, and this is a step forward for the Tata Group. What does it now mean in terms of strategy for the Mistry side?
We will certainly need to pursue an appeal. This matter is about our worldview of what is good governance versus the other side's worldview of what is good governance. One will have to read the detail in the order to look at what form and manner the contents of the appeal would be. But surely the very fact that these proceedings were pursued was only because this would be taken to its logical end, whichever way. We will need to wait for the order. It is, of course, disappointing, but our sight is now on the appeal.
You know, you said that this is a difference of opinion between your worldview on corporate governance and the other side's worldview on corporate governance. But this is the NCLT virtually on every plea that you had made, saying that that your plea doesn't hold ground, whether it is on the allegation of saying that the trustees were acting as a super board, that there was oppression, that there was mismanagement. I mean, on virtually all counts, it has been a wholesale dismissal, to quote Mr. Mohan Parasaran.
Yes, it is, which is why there would be an appeal. I mean, in all adversarial proceedings, there are two competing views. At each stage, one view or the other prevails. We have our conviction and our faith and belief in our view of what is good governance, and that would be pursued.
So what will be the grounds for appeal? So given what we have seen now, the NCLT say, even when it comes to things like upholding Article 75, which was again a bone of contention and part of your plea in the NCLT, what is going to be the grounds for appeal?
Well, all the grounds that were taken in this petition would be up for review in an appeal. So if there are three specific reliefs that we sought in terms of reform of the charter, in terms of board representation, and in terms of the very constitutional nature of the company, those have not been given. So those are the three we would continue to pursue.
Okay. But given what the NCLT has said, Som, are you hopeful about the appeal going anywhere?
When I say we have conviction and resolve in pursuing this, that is what it means.
Okay. All right, Som, well, we wish you the very best of luck. That's Somashekar Sundaresan, the Mistry Council, saying that they will appeal. They have conviction and resolve to take this forward. This is, of course, expected, as we pointed out, that this is a matter that will go into appeal. I wonder if we still have Mr. Parasaran with us. Mr. Parasaran, you heard the Cyrus Mistry Council, Somashekar Sundaresan, they're saying that they continue to believe that that they have reason and cause for an appeal and the grounds will remain the same. Your first reaction?
See, that is my point of view. Even as I said, having fought this much, logically, I think they would naturally file an appeal. Let them file the appeal. We also have a strong conviction that we have a good case. We will fight it out, no?
But where do you believe, Mr. Parasaran, could be the vulnerabilities, if any at all, given what we've seen the NCLT say today?
See, I don't think that this petition is, first of all, maintainable on the grounds of acts of oppression and mismanagement. Because we have been right from the beginning saying that Mr. Mistry has been part of the company. And he was actually parties to many of the decisions. Therefore, the fundamental fulcrum itself is defective. And let us also actually meet the challenges met to the articles. The family itself, Mistry's family itself, was party to the various amendments brought about to the various articles of association. Therefore, we have a strong conviction that we have a good case even before the NCLT.
Okay. How soon do you expect that we could see the possibility of this now moving to the NCLAT?
I'm not sure. I think possibly, it's a long-list judgment. I think they should file it, in a matter of 2-3 weeks, no?
Okay, file it in a matter of the next 2 to 3 weeks.
Yeah.
We've got our colleagues Yash Jain and Arun Giri who've been standing outside the NCLT while the order was being pronounced. Mr. Parasaran, I request you to also hang in there. Arun, Yash, thanks very much for joining us. Arun, Mohan Parasaran here with us. Any questions for him, and of course any more that you've been able to get from the order?
The order is not going to be uploaded today. The judges were very clear. They want to very carefully read every line what they have written and then upload it. So they don't want any room for further interpretation or any objections. But for Mr. Parasaran, two important questions. Number one, that the NCLT has gone into the merits of each and every allegation and dismissed every allegation that Mr. Cyrus Mistry or the Mistry Group has made against Tata Sons, as well as Mr. Ratan Tata and Mr. Soonawala. That would be a bit heartwarming to the Tata Group side, Mohan sir. The fact that every allegation from Nano Project to Air Asia to C. Shivasankaran, whatever, all the allegations of a personal nature, you all would say, have been dismissed.
Absolutely. Absolutely. It was read out in court, no?
Absolutely.
Yes, it was read out in court, and Arun is pointing out that is going to be big relief for you.
Absolutely.
Yeah, Mohan sir, there is one more important point that the order clearly said, that Mr. Mistry leaked information to the media, he leaked information to the income tax authorities, and this could have hindered the smooth functioning of the group, and therefore his dismissal was right.
That was the argument which was put forth by the Tata Group, and that argument has been accepted by the NCLT.
And therefore, sir, on this line, since this argument has been accepted, do you think this gives you now a handle to take some further action on the legal front against Mr. Mistry?
Yeah, that actually we have to still examine the judgment. We have to see what sort of a reasoning has been given in the judgment, and then we'll have to think about it and take a call, no?
Yeah, absolutely. Shireen, that is a very important point, that not only on any technicality,
wanted to pick up
but
on Arun.
merits, the NCLT has ruled that the dismissal was right. They've said very clearly that the dismissal was right. They've also said that the board of directors had the power to dismiss the executive chairman. So they've upheld the powers of the Tata Group. I have one more, sir, an allegation of a personal nature that was made against Mr. Tata and Mr. Soonawala, but mainly Mr. Tata, that he was acting as a super director. And one of the key arguments of the Cyrus Mistry Group, which I distinctly recollect, was that the articles of association and Tata and the power given to Tata Trust make the board of Tata Sons a dummy. They've rejected that argument, and they have clearly said and concluded that Mr. Ratan Tata is not a super director. Mohan sir.
Yeah, that's right, because for that purpose, factually materials were placed before the NCLT, no? That actually we are not acting as super directors, but we're actually acting as the practice and custom. We are only giving advice from time to time, and we were also, you must remember, that the trust was a majority director, and advice was sought for from the trustees by the company and by Mr. and Mr. Mistry. Those facts must have been taken note of by the NCLT, I think.
Mr. Parasaran, just to pick up on the point that Arun was making, sir, and I wanted to ask you that, given what we have seen today, specifically on some of the allegations that Mr. Mistry had made, as well as the NCLT pointing out that the Mistry camp's that Cyrus Mistry's behavior did not augur well, also saying that information was leaked, would you now contemplate any kind of legal action?
No, not as of now, but we have to examine the judgment. We can't jump into any conclusions now. And we are primarily concerned with actually taking the company forward. And this litigation itself actually has diverted the attention of the executives of the company in several ways. And now I think they have to concentrate more on the business. That's what I was told.
Okay, concentrate more on business and I think that...
Shireen, I want to ask one more question.
Yeah.
Shireen, I want to ask one more question
go
to
ahead.
Mohan, sir. I won't let him go so easily. Sir, you've seen Vodafone. We went right from Bombay High Court, then to Supreme Court, where over 28 days the arguments were heard. You potentially, with the NCLT, we had directed NCLT to hold expeditious hearings and pass an order, which the NCLT has done. The NCLT, in all probability, will hear the matter soon and pass an order. So therefore, sir, you're bracing for round 2 and round 3. How will this, end very soon?
See, this will be an ongoing battle unless and until I think parties see some reason and arrive at some sort of a solution amongst themselves. Otherwise, I think it will be a long-drawn battle.
Yeah, and I have one last question, sir.
It will be a long-drawn battle.
For Mohan, sir. No, Shireen, I have one last question. I have one last question for Mr. Parasaran.
Go ahead.
And that is that the articles of Tata Sons say that the minority shareholders cannot transfer the shares without the approval of Tata Sons. I think it's Article 75, which gives you the right to restrict the share transfer. The question now is, sir, in case Mr. Mistry is looking to sell his shares in Tata Sons, the Mistry Group wants to sell his shares, would you be okay with it? Or would you want to buy those shares? That's the question.
I think Mr. Mistry has made it abundantly clear before the NCLT that he is not inclined to sell his shares. And I think in the present position, I think he won't, be inclined to sell his shares. And as far as I am concerned, I think no decision has been taken by the company to compulsorily acquire his shares as well.
Okay. All right. Arun, I'm wondering if Yash has any questions for Mr. Parasaran before we let him go.
Yeah, and yes, could you please bring to light with some of the key observations of the NCLT?
Right. So, of course, when we talk
you.
about the allegations which were made on the personal front and the board, they've been
Mr.
taken
Parasaran,
care of and
appreciate
answered
it.
by the bench of NCLT. Of course, one question was on the equity part. My second question is, sir, when this goes
Mr. Parasaran has left, so maybe we can take a couple of points on the NCLT order.
Okay, as far as 4 points of allegations where there were objections which were raised from the Cyrus Mistry side. One was on the formation of the private company, turning into a private company, which Tata Sons is right now. The court hasn't found any merit in the arguments which went against turning Tata Sons into a private company. The second one was when it comes to mismanagement, which was done by the board of various Tata Group companies. There were various companies named, be Tata Motors, Air Asia India, Tata Steel, Tata Teleservices, and all those. No merits have been found as far as mismanagement is concerned. The decisions were taken as per the board consensus, and then the board went ahead with them. The third one was interference. As you rightly mentioned, there were allegations that the board, especially Ratan Tata and Mr. Soonawala, interfered when it comes to the board decisions, when it comes to the various operating companies. The court also hasn't found any merit, and the court has said that they were the guiding part when it comes to all these decisions and the board. And the fourth one was the transfer of equity. Of course, there was this particular fear that Tata Sons has the power to forcefully transfer the equity, 18% equity.
Forcefully acquire it.
Exactly, which the two firms of Cyrus Mistry, Cyrus Investments and Sterling Investments have. But yes, assuming the court hasn't made any specific remark when it comes to that, but Mr. Parasaran has mentioned to us in that interaction that yes, no objection, the court has ruled out any sort of objection when it comes to that forceful transfer as well.
Yeah, Shireen, very important on that, the point that Yash makes. There were 2 articles in the Tata Sons Articles of Association which Cyrus Mistry Group hotly contested. One was Article 121, which gives Tata Trust the power of affirmative vote, which means there are some 8 or 10 items which Tata Sons cannot take any decision without the approval, the affirmative vote of the nominees of the Tata Trust on Tata Sons. The affirmative power of Tata Sons, that article of Tata Trust, that was drawn from Article 121. That amendment came some 3 or 4 years back after Mr. Mistry became the chairman of Tata Sons. That amendment was hotly contested by Mr. Mistry, and they urged the NCLT to strike down these amendments or amend these articles 121 to reflect the concept of board management and not give any super authority or any superpower to the nominees of the Tata Trust on Tata Sons. That request or that plea has been clearly rejected. That is one of the key key, pleas that were made by the Cyrus Mistry group. And of course, the another one which Yash referred to was transfer of shares. The Article 75, I think, gives power to Tata Sons to forcefully acquire the shares of Mr. Mistry. They have not exercised that power as yet. I'm sure they don't want it to go into another round of litigation. Even that has been rejected.
Well, Mr. Parasaran caveated that, saying that no decision has been taken on compulsorily acquiring his stake.
They are not oppressive, and they are not oppressive in the Cyrus Mistry group. Here, it's very important to point out that the argument of Tata Sons, Counsel Dr. Abhishek Manu Singhvi, Mr. Parasaran, Mr. Ravi Kadam, all of them was, this is an afterthought petition.
Okay. All right. Gentlemen, we are going to have to leave it there, but we leave it on the note that it is a victory for Tata Sons, a dismissal of the plea filed by Cyrus Mistry. The Tata stocks mostly reacting positively to that. As the Tata Council told us, the group wants to get on with business, and perhaps this will ensure that N. Chandrasekharan can put his mind, his management bandwidth to doing exactly that. We'll take a break, come back with the markets and a lot more.